Gina with Clearview Media and Doug White on scene actually in Tampa, downtown, supporting an amazing patriot, someone that's been in the fight for many, many years, knows how the political system, judicial system I should say, is pretty much corrupt and is currently fighting back, traveling nationwide. But first I kind of want to introduce you to Tanawah. Tell us a little bit about your background, how you've gotten into the fight. Obviously your background is impeccable. Military, correct?
Yeah.
Also an attorney.
I'm an advocate, but we'll explain that in just one moment here.
Yeah, but you've worked at Gitmo, things like that.
Yep.
So, and you've also won a huge national case. Yep. So tell us a little bit about how you started, your background, and then we'll continue
Sure.
from there.
So my name is Tanawah Downing, and thank you guys so much for coming out here. We're in Tampa, Florida. This is actually the 19th stop on a 40-stop tour around the country, bringing and raising awareness to a number of pretty major issues that we need to get addressed here in America, right? And so, yeah, my background is I was prior Special Operations Navy. I was in the Navy for 9 years, Special Operations Officer. I left there and I went to work for an intelligence agency for a few years. And this was right at the time of September 11th. So, you know, I got to know very, very in-depth the issues with Guantanamo Bay, the things that we were experiencing, and how that's now impacting our society. And you know what I like to say is that it's a shame that our global war on terrorism has entered into our own borders and so dramatically impacted our own citizens, because this is a terrorist issue that we're looking at being implicated by or being infiltrated by our own government. Because terrorism, by definition, is a threat or use of threat of fear in order to bring about a desired result from one organization to another organization. And so, you know, the base issue is this, is that Guantanamo Bay, what was happening was that there would be an allegation. Some information would be given to the CIA or Homeland Security that someone was a terrorist, right? And they would go out and they would arrest him based upon a single set of information, not confirming it. And then they would find that person, bring him into Guantanamo Bay, Cuba, where we would put them through deprivation tactics, which would mess with them sexually, physically, emotionally. And we would continue these tactics until such time as they agreed that they were guilty of whatever it was that we were alleging that they were guilty of, right? But these tactics, they were designed to make a person become the very object that they say that they were. Because what we've learned in hindsight, you know, after many years of looking back on Guantanamo Bay and the things that we were doing, was that most of the people that were sent to Guantanamo Bay, they weren't terrorists when they got there,
right?
But they were when they left.
Well, they almost like brainwashed them. That would go back into the MK Ultra and actually conditioning them.
And so what we were doing was we were actually creating the very object that we were going out and fighting against in order to justify the war on terror. They weren't a terrorist when they got there, but they were when they left. And the sad thing is that the same exact terrorist tactics that were the deprivation tactics that we were using down in Guantanamo Bay, we use every single day in every single jail and prison across this country now, which is justifying our war on crime, because we're creating the very objects that we go out and fight against every day within these institutions based upon a single set of information, a single set of fact that has never had the opportunity to be able to be confronted in a fair and neutral decision maker. And so therein lies the real issue is that the things that we did and learned in Guantanamo Bay, Cuba, we are now employing across this country on our own people, and we've got to stop this.
So that goes back to the community levels, correct? I mean, city, county, state, and explain a little bit about why you're kind of going out there right now and what your mission is, because that's what we're seeing right now.
Yeah, so the We Shall Be Free tour, again, so 9 years ago, I was on the other side. Guys, I owned an engineering firm. I was extremely successful, making $870,000 a year. We were the 13th fastest growing company in Washington State. The following year, we were the 22nd National Emerging Small Business. I did major design, technical design engineering programs for seaports, airports, transit authorities. The last project I was on was the Los Angeles Fort Airport's security implementation program. I was the chief architect and managing consultant. And then we were getting ready to bid on the Pentagon's video surveillance implementation program. I was considered a shoe-in for it. I was the youngest chairman of the National Physical Security Council. I was named Best and Brightest in 2016 by National Security Institute. I know Homeland Security, and I've come to understand that Homeland Security is simply code word for domestic terrorism. You don't protect the government from the people, you protect people from the government. I was on the wrong side. And so 9 years ago, I had to step back and realize this issue and the fact that we were going in the wrong direction, and therefore the programs, solutions, technology that I was personally responsible for implementing, I had an obligation at that point to address and correct at a minimum, because that was not the right thing to do. What we were doing as a result of Homeland Security, the tragic events of September 11th, we had to change. So 9 years ago, I switched sides and I went into litigation full time. This is my first love. I have a degree in what's called substantive law, right? So you were saying attorney a moment ago. Guys, I'm not an attorney. I would never claim to be an attorney, because attorney is an administrative officer of the court. They go through what's called adjudicative law. Yep. They learn about the adjudication process. So they learn about ordinances, customs, statutes, judge-made rulings, all of the laws that remove freedom, because that's what they're in the business of. They make a person into a criminal. So they are in the business of removing freedom. I have a degree in substantive law. I went to the most expensive university in the United States. I got a 3.98 GPA, graduated on the South Lawn of the White House. I know substantive law. I studied nothing but the Constitution my entire degree. Nothing but the Constitution.
So how is, obviously, we know that the U.S. Constitution has been the most used against we the people.
Yeah.
And I know you've expressed that multiple times. Tell me a little bit about how, what articles, obviously, because I know you know very deep on how they've weaponized that against us citizens.
Yeah, so, that's a great question, because where did this all go wrong? Well, here in America, and let me go ahead and this is part of my oral arguments, in fact, so Supreme Court, go ahead and take note of this, right? Because you need to understand here. So we live in what's called government of laws. There are two political theories that exist. One is government of laws, the other is judicial realism. Now, government of laws doctrine is constitutionally based, and it's built upon the theory that in order for laws to be legitimate, they must be considered equal. This is the egalitarianism approach, which our Constitution is framed upon. But in order for all men to be equal, government laws must first treat them equal. That's the way that our system is designed to work, based upon a fixed set of laws or principles in which the courts and people adhere to, and to which every person is accustomed to. But the opposite of government of laws doctrine is legal realism, which is very much alive and at work here in America, destroying our system of government and infringing on the rights of people. Legal realism is the belief that law is not based upon a formal set of laws or principles, but instead upon judicial decisions that derive from their own social, political, or public policy. This is not constitutionally based, as it does not permit the fair and equal treatment of people. Legal realism is the world that we live in today, because we believe that judges make the law. So we the people, we created the fundamental law called the Constitution of the United States. We ratified it on September 17th, 1787 in all intents and purposes, and then we ratified and adopted the Bill of Rights on December 15th, 1791. That's what we believe. We believe we can look at that, we can predict our future, because we live based upon a government of laws. The rule of law is in place, right? But the question is if you go into a courtroom and you say that your rights have been violated, where does that judge go to determine whether or not your rights have been violated? Does he go to the Constitution of the United States of America, or does he go to a judge-made ruling made from 1887 to determine whether or not you get an indictment by a grand jury? The answer is he goes to a judge-made ruling, which means that the Constitution is not the foundation, judge-made rulings is the foundation. And so now we have a situation where judges have created their own rulings, adopted and put them into place erroneously and unconstitutionally, called them law, because judges can't legislate. Judges have no authority to be able to create law. Exactly. And so when they do create rulings and then they erroneously and unconstitutionally call that ruling a law, case law, that would be unconstitutional. So let me just tell you about the three branches of government real quick. The first branch of government, Article 1, Clause 1, says that all legislative power is vested in a Congress of the United States consisting of a Senate and a House of Representatives. All power to legislate. Legislate means make law. Make, create, amend, destroy, everything that has to do with the law is vested in the first branch of government. The legislators legislate. No other branch of government can do it. They create law. Law affects the people. The second branch of government, Article 2, is the executive branch. The executive branch is the president, right? Now, what the president creates is called orders, executive orders, right? He doesn't create law, he creates orders. Orders don't affect the people. Orders can only affect those that can be ordered. Exactly. So the president orders his law enforcement, right? His prosecutors, right? And the attorneys, right? Because they fall under the attorney general, okay? So the president is able to order his workers, all the law enforcement branch, to follow those orders. Yep. Now the third branch of government, Article 3, is the judicial branch. It's known as the administrative branch. They're there to administer the law. Second branch of government, the executive branch, enforces the law. The third branch of government, the judicial branch, administers the law. So when the administrative branch creates a ruling, because that's what they do, judges create rulings, judge-made rulings. Rulings only affect those that are being ruled over. So the people within the courtroom, including attorneys, right? Prosecutors, they're the ones that can be ruled over. That's why when you go to an attorney says to you, this judge said this, that's the law. Well, maybe in your legal philosophy, but
right,
not within the American philosophy, because here in America, we didn't delegate any authority to legislate whatsoever. So the truth is that the English bar, what they do in England, their attorneys are taught that the judges create the law because the king did delegate the authority for his agents to be able to speak the law. In England, judges do speak the law. What they say is the law. But the problem is that philosophy has entered into the United States, permeated across the entire country, because here in America, we believe that judges are able to create law, and they cannot. So in 1833, when the United States Supreme Court came out in a case called Barron versus Baltimore, and they stated that the Bill of Rights are not a restriction against the state governments, only a restriction against the federal government. As of that moment, all of those rights contained within the Bill of Rights, including freedom of speech, freedom of religion, freedom of press, the right to indictment by grand jury, they were all removed because they're not a restriction against the state governments, only a restriction against the federal government. And that created something known as dual sovereignty, where now we have a situation where whatever the state gives you, as long as you're in a state court, right, that whatever they give you is what you get. You don't have the ability to bring it in because they are not restrained by the Constitution. And now we have a pretty major situation.
That's, I think, the division is going on too within the states, right?
Yeah.
So Trump has been doing all these executive orders, but then now you're seeing the local state governments, counties, saying, no, we're not going to do it. We're not going to follow rule of law, right?
Sure. Yeah, so there's three issues. So when our country was first established, right, we were originally a confederacy. So 1776 until 1787, we were a confederacy. Now let me tell you, a confederacy is defined as two or more sovereign states with a loose decentralized governing structure, right? A sovereign state is defined as a state that is complete in itself, not subject to a higher government's laws. Let me say that again. A sovereign state is a state that is not, or that is complete in itself, not subject to a higher government's laws. So we had a confederacy with a bunch of sovereign states, and they said, well, we're sovereign, we're not subject to the laws that are created by a central government, and this was a problem. This was why we had to go into that Constitutional Convention to begin with, because we had these states that were picking and choosing which parts of the central government's legislation they wanted to actually employ or not. Right. They were doing whatever they wanted to do and saying, oh, this doesn't work for us, we're not going to do it. And there was no way to get the states to actually implement the laws that were created by the central government, right? That was the first issue.
So that's one of the ways they've infiltrated and separated and division.
And therein lies this issue of sovereignty, because if a state is sovereign, then that means that they're not subject to the higher government's laws, which means that they don't have to follow the Constitution. States are not sovereign. We live in a union. A union is defined as two or more non-sovereign states with a centralized governing structure, and a sovereign state is a state that's not complete in itself, subject to a higher government's laws. We've got to address this sovereign immunity issue, this sovereignty issue. Now it's interesting because sovereignty derives from an English doctrine known as the king can do no wrong. King can do no wrong, okay? So in England, the king creates the laws. It's a monarchy. He creates the laws come from him. Therefore, you can't arrest a king, you can't sue a king, because that king is sovereign. He would just change the laws. So, but here in America, we the people, we create the laws. We are the sovereign, right? So you can't sue the king without his consent, because he's the creator of laws. Here in America, you can't take a person into court without their consent. It's the same philosophy for the people as the king, right? So you must consent to be brought into the courtroom, because we, the people, are sovereign, and in our sovereignty, we created the laws of the United States, which then created the courtroom that calls in. Now, the reason why I bring this up is because in English tradition, the king is known as nobility, right? Nobility. Well, to initiate a criminal action here in America, right, it starts with what's called a bill of indictment, right? A bill of indictment. So if you choose to violate the law, you incur a debt to which you're charged and then called to account so you can pay the debt. These are all very simple accounting terms. But the way the debt normally works is, if I want to purchase something from a store, a bill is first generated, which I sign and accept.
Yep.
Then my account is charged and I incur a debt to which I then have to pay. These are very simple methods for very simple method for transactions that anyone can understand. However, if the store charges a person's account without billing them first, that's called fraud. You must always bill before a charge is generated. And how this applies to this case that I'm getting ready to litigate here across country is that an indictment by a grand jury is called a bill. So absent a grand jury indictment, there is no bill. Therefore, the charge is being generated is fraudulent because there is no bill that was used to create that charge. If you charge someone without billing them first, that is called fraud.
Right.
That's what makes these fraudulent. So here in America, Clause 1 of Amendment 5 to the Constitution, I think we would all agree that that's part of the Constitution of the United States of America. No one is arguing that. What it says no person shall be held to answer for a capital or otherwise infamous crime unless on presentment or indictment of a grand jury. That's clear. You got to have an indictment by a grand jury before arresting someone or holding them over for a capital or an infamous crime. Now, a capital crime is any crime punishable by a death. That's pretty easy, right? But an infamous crime, you got to dig a little bit deeper to figure out what that is. Infamous crime can be defined by Title 18, subsection 4083, as any crime punishable by more than 1 year imprisonment in a penitentiary, okay? Now, it's not the amount of time you get sentenced to, but the amount of time you can be sentenced to, because the Constitution says no person shall be held to answer for a capital or infamous crime unless on presentment or indictment of a grand jury. So it's the moment you're arrested that determines the infamous nature of that crime. So even if you only got 3 months, but you could have gotten 2 years, it is still an infamous crime requiring the indictment by a grand jury. The reason why I bring that up is because there's 13 states right now today that do not conduct a grand jury at all, including the state of Washington. Article 1, Section 26 of its inferior constitution says no grand jury shall be drawn or summoned in any county. That's very interesting because that's a state that has a provision in its inferior constitution that functions directly to the contrary of the Constitution of the United States of America. Now we have a supremacy issue. Now we need to determine which law is supreme. Does the state of Washington have the authority to be able to create a law in its inferior constitution and then direct its agents to go out and enforce that inferior law in violation of the Constitution of the United States of America? The answer is no, because a crime is committed the moment that happens. It's not just Washington. It's also the state of Pennsylvania, the state of Michigan, the state of Connecticut, the state of Oklahoma, the state of North Dakota, South Dakota. These are states that are acting in direct, willful defiance of the Constitution of the United States of America. And this is a big deal because today there's more than 700,000 people currently in prison across America on direct facial constitutional violations because the states didn't follow the very basic steps and practices codified in the Constitution of the United States for the adjudication of a crime. Those are the people we got to fight for. Because here in the state of Florida, where we're at right now, Florida has enacted its own inferior constitutional provision that permits the prosecuting attorney to charge by information or indictment by their discretion. That's a problem because what that provision allows the prosecutor to do is to decide who gets a constitutional right and who does not, making it a violation of the 14th Amendment's Equal Protection Clause. No state shall create or enforce any law that does not provide equal protection of the law. State of Florida, you're currently acting unconstitutional, and every single criminal adjudication that you're going through right now as of this moment is all unconstitutional and therefore void, wholly without force or effect on the parties involved in the dispute. You must correct your unconstitutional provisions and you must obey the will of the people. We've established the laws, obey them, or nothing that you do, nothing that you create is going to be valid.
Which that makes sense because Florida, you know, with the J6ers, when Trump released all the pardons, we had several here that were the remaining 4, as we call them, and there's still 2 more that the Attorney General, the judicial system, will not let them go. So that makes a lot of sense where that comes into play. So now, how do people kind of get activated? How can they contribute and help doing what you're doing? Explain a little bit about why you're traveling around. I've seen your affidavit. It's beautifully written. I know you've been serving all the AGs and all the states. So talk a little bit about your mission on that. And then what's to come, obviously, because we know you're headed to Washington next month.
So Washington, D.C. Is where the Supreme Court of the United States is at. I started a case 9 years ago against the state of Washington and its inferior provision. And I could beat Washington at any moment. But I don't want to just beat Washington. I want to provide relief to the people of the United States because those ones here in the state of Florida that are being held unconstitutionally, they deserve to have those rights that are guaranteed to them, given to them. So I can't sue the state of Florida, for instance, because that would be a violation of the 11th Amendment. The 11th Amendment limits a citizen in one state to sue a different state. So I can't sue the state of Florida, but there are plenty of people here that can, right, under this same exact issue. So we're bringing the indictment issue in order to have a much bigger question, but nonetheless, when a state chooses to enact its own alternative legislation, substitute that for the guarantees of the Constitution of the United States of America, and then direct its agents to go out and enforce that, that would be unconstitutional. In fact, it's the crime of sedition, because sedition is defined as the speaking or writing of words, such as law established, in order to cause disaffection to the Constitution, to procure its alteration in an other than lawful manner. If you create a law or speak a law that is intended to alter the Constitution of the United States of America in an other than lawful manner, that is sedition at its most basic definition form, right? You may not alter the Constitution in an other than lawful manner. So when a state does do that, and then directs their agents to go out and enforce that inferior law in violation of the Constitution of the United States of America, they just committed a crime. It's called deprivation of rights under color of law, Title 18, subsection 242. What 242 says? It says any person who, under the color of any state statute, ordinance, custom, or regulation, deprives any person of any right secured by the Constitution, commits that crime, right? This is what's known as a per se crime, which means that I don't have to prove that they intended to breach their obligation. Simply by virtue of the breach, all elements of the crime have been met, because their willfulness and their knowledge derives from the promise that they make. If you make a promise, you take an oath to abide by the Constitution of the United States, what you're doing is you're promising a future outcome. And if you fail to fulfill that outcome, willfully or negligently, it doesn't matter, you have committed that crime. It's per se, because you've already implicitly invited punishment in the form of perjury should you fail to fulfill such promise.
I want to step back a minute, because I think you touched on something that's very important. So you mentioned England a lot.
Yeah.
So from what I've read in the Constitution, almost the second paragraph in that Constitution says no terms of nobility shall hold office.
I didn't get to finish my point. Yeah, you're right. Because this will go back to what we were talking about.
Yep.
So that's a great question, right? And so, again, a king in England is known as nobility, right?
Right.
So the way that you initiate a criminal action here in America is you must bill them a bill of indictment, right? A bill of indictment.
Yep.
So that's why a king, right, in England, he has nobility, because you can't bill a king for a crime because he has nobility, and there's the etymology of that word. That's where that word comes from. Nobility means you cannot bill a king because he is immune from your billing. Yeah. People cannot bill the king.
That's like a ticket or a charge, right?
Right. So any criminal action. So you cannot sue a king or arrest a king without his permission, without his consent, right? Because he has nobility. You cannot bill the king because he has no bill. No bill.
So are we under England's laws, or are we under the United States laws?
Well, we morphed into English, in English
18,
tradition, because
1800s,
another interesting thing with nobility is that they receive what's called an honorific. They all receive an honorific. An honorific is a term or title that goes before their name. So Sir Tanawah would be a great honorific, right? But it goes before your name, and it identifies you as being honorable, of honorable nature. And these people here in America, do they not use an honorific? In fact, they use the very word, the honorable, the honorable, the honorable.
Hillary Clinton.
That is an honorific placed before their name as a sign of nobility. However, Article 1, Section 9 says the United States shall not create patents of nobility. Article 1, Section 10 says no state shall have titles of nobility. So as a result, you can't have nobility. Everyone is billable for their crimes here in America because no one is immune from their criminal liability of action. And even nobility, right? Yeah, everybody's billable. It doesn't matter who you are. Now, I'm not going to go into the Trump immunity situation, because I don't think that your audience necessarily wants to hear about that. But because I believe that there were some deceptive intentions, we got to understand this Supreme Court of the United States, they're not trying to find a way through this right now. They're still trying to find a way out of this. What we're doing. Yeah. Because again, today there's more than 700,000 people currently in prison in America on direct facial constitutional violations, because the highest court in the land, the United States Supreme Court, has directed every single court within its purview, all the state courts, that they don't have to follow the Constitution of the United States of America, and that is still standing Supreme Court precedent today, That's the reason why these states believe that they do not have to have an indictment by a grand jury, is because in 1833, the highest court in the land said you don't have to provide an indictment by a grand jury. And all these states said, oh, it sounds great to me. And they went out and enacted their own alternative laws in their own inferior state constitutions that says we're not going to do what the Constitution of the United States requires us to do because the judicial branch said we don't have to do it. Unfortunately, there, Supreme Court of the United States, you have no lawful authority to be able to alter, amend, or destroy any of the provisions that guarantees the Constitution. That must be done by an authentic act of people in accordance with the special amending procedure of Article 5. So when you chose to amend the Constitution of the United States, removing the fundamental rights of the people codified and enumerated within the Bill of Rights, and replace it with your judge-made rulings, Barron versus Baltimore, when you did that, what you produced is unconstitutional, and as a result, states, all of your inferior laws that relied upon that inferior judge-made ruling that was erroneously called law that fundamentally changed the Constitution of the United States, they're also unconstitutional. And if they're unconstitutional, then that means that every single criminal contract that you're creating states that relied upon your inferior state statutes to be created are all void, because they're created by something that was unconstitutional, relying upon a branch of government that has no authority to legislate, and yet they chose to sidestep and overstep the separation of powers, legislate from the bench, and rule the people in a manner that they see fit, as opposed to the people and their will.
And that's the wheels of our legal system, right? Contract law.
Contract law, right. The whole thing, yeah. Right. Everything is a contract, right?
Yeah.
But and this goes into the plea bargain issue, because you know, it's an egregious failure of our justice system that today 98% of all convictions come by way of plea bargain. Yep. That's 98% of all criminal defendants that don't even get to tell their side of the story, and that is an egregious failure of our justice system. Plea bargains aren't constitutional. They're not legal.
Yep.
Because the Constitution of the United States of America, in Article 3, it says, the trial of all crimes, with the exception of impeachment, shall be by jury, and the trial shall occur in the state in which the crime is said to have been committed. If you don't mind, let me just go over rights for a moment, because a lot of people really don't understand where their rights come from. Your rights do come from God, don't get me wrong here, but let me explain a little bit more about rights, because this is really to my heart, right? This is what I specialize in, is rights. Where do rights come from? Substantive law, that's what I specialize in. So, according to the doctrine of duties and rights, rights always derive from another's duty to act. Where there is no duty, there can be no right. Now, there are duties that exist that do not have a right, such as duty to God, duty to spouse, or duty to country. I have no rights that exist because I have to obey God, but I still have a duty to obey God. So, but there are no rights that exist without a corresponding duty. And the reason why is because the law creates a duty. Every law creates both an obligation and a right, okay? So, for instance, I have an obligation to not kill someone. I have an obligation to not assault someone. I have an obligation to not rob someone, because the law says thou shalt not rob, right? So if I do go out and rob someone, then their right to not be robbed has been violated, but it isn't violated until someone breaches a duty, breaks the law. So that's what the law creates. Now, an obligation can be seen from two perspectives, right? From the one bound, the obligation is a duty. From the one entitled, the obligation is a right. So every law creates that obligation. The obligation binds someone to adhere to it, and the other side grants someone a right. So the main body of the Constitution, Articles 1 through 7, right? Those create the obligations of government. Nowhere within the first 7 articles do you see a right. Yeah. Article 4, you see that they allude to the existence of rights, such as where it says that the citizens in each state shall be entitled to all privileges and immunities as the citizens in the several states. That's not a right. That's actually pointing to the fact that if a citizen in one state has a right or an immunity, that you must provide that in all other states. Exactly. That creates the backbone of our egalitarianism form of government, where all men are treated equally because the laws apply equally to every single person within our jurisdiction, right? But nowhere in the first 7 articles do you find a right. Those are all duties. So again, going back to Article 3, where it says the trial of all crimes, with the exception of impeachment, shall be by jury, and the trial shall occur in the state in which the crime is said to have been committed. Is that a right or is that a duty?
Right.
That's a duty. Because it's directing someone as to the way to adjudicate a crime, with the exception of impeachment, right? They all must be done by a trial by jury. So when you walk into a courtroom and that judge says to you, do you want to give up your right to trial by jury and enter into this plea of guilt? That judge must break the law in order to ask you that question, which is why the rights are inalienable. You cannot give them up. And this is upheld by a number of different places. Miranda versus Arizona is a great place. Miranda versus Arizona says, where rights secured by the Constitution are involved, there can be no rule or legislation created which would abrogate it. No ruling, no judge-made ruling, because judges don't create law. No ruling can be created which would abrogate the Constitution, and no legislation, because the executive branch also has no authority to be able to alter the Constitution of the United States. It must be done by an authentic act of people. So Miranda versus Arizona talks about that. Where rights secured by the Constitution are involved, there can be no rule or legislation created which would abrogate it. We can also find this within the rules of civil procedure, right? Where it says that rules must not conflict with statutes, nor impair the legal rights of the parties involved. Thus, a court has no power to create a rule which would constitute a waiver of a constitutional right. You may not ever waive a constitutional right, because those are obligations of government, and those obligations come before your right, because rights always derive from another's duty to act. So if a judge says to you, do you want to waive your right to a trial by jury and enter into this plea, in order to do that, in order to create that contract, that judge has to breach his obligation of ensuring that the trial by jury is there, thus codified in the law, and now that judge broke the law to enter into that contract. So that makes that contract unconstitutional. Everything we're dealing with is contract law. Every bit of it is contract law. And we can void these contracts by the breach of the contractual obligations, because the first terms of the contract, remember, a lot of people say that attorneys, they don't have a first duty to the client, they have a first duty to court. We all know that, right? The corpus secundum says it, right? The attorney's handbook says just that. But the problem there is that attorneys might have a first duty to the court and not to the client. But that judge in court has the first duty to the Constitution and not to the court.
Right.
Because here in America, we the people in our sovereignty created the Constitution. The Constitution then created jurisdiction. Remember, jurisdiction is statutorily created. It exists before a court. So the jurisdiction is what creates the court, and then the court creates the court's agent. Therefore, jurisdiction is above the court. So if a court takes action when it lacks jurisdiction as a first duty, because it can't exist without jurisdiction. Therefore, if a court takes action lacking jurisdiction, then anything that it produces is unconstitutional. The same thing applies, that if the Constitution is the contract that creates the jurisdiction, the delegated authority from the people, when they act outside of that contract and they breach the terms of their contract, by the breach of their contract, they nullify the second, because you can never breach the terms of a contract in order to enter into a second contract without making both those contracts void.
So on the contract issue, right? So my understanding of how a contract should work is that both parties should understand that contract. So it should be that simple, right? You should be able to, any person look at this contract, understand it, and agree to it or not agree to it. So why do we have attorneys that have to tell us what the contract says?
Because the attorneys have convoluted it through their training. So the attorneys are trained in following judge-made rulings. That's why when you walk into a courtroom with an attorney, that attorney is going to say to you, oh, this judge, what he says is the law. No, it's not. What the Constitution says is the law, right? So if the Constitution says no person shall be held to answer for a capital or otherwise infamous crime unless on presentment or indictment of a grand jury, I'm going to say, show me where in the four corners of that contract it says you don't have to have an indictment by a grand jury. And if you cannot, I win, right? Because the contract says you must do it. Judge, when you entered into your office, you swore an oath. That oath is with and to the Constitution directly. Your fidelity is bound to that object, right? Not to the flawed decision of the piece of shit that came before you, or the flawed decision of the flawed man that came before him. Your responsibility, your duty, your first duty is to that Constitution, because you swore by oath or affirmation that you would have fidelity with and to it. And as a result, if you breach that, you've already implicitly invited punishment in the form of perjury, right? And perjury, unfortunately for you judges, is a violation of public trust, meaning you can no longer be trusted by the public. And guess what? Once again, perjury is a per se crime. I don't have to show that you intended to do it, because your willfulness and your knowledge derives from the promise that you make. Judges and prosecutors, you better figure out real quick here where your faith is at, because when you choose to violate that which you swore an oath to, don't be surprised if the punishment is death.
Yep.
God warned you in Genesis, right? If you eat from the fruit of that tree, the punishment is death. And I'm telling you right now, prosecutors, judges, all you public officials, when you eat the fruit of treason, the punishment as prescribed by law is death. You got some bad stuff coming your way right now, and you might want to wake up and figure out where your faith is at, because I can't protect you from what the people are going to do. All I can do is bring this to their attention and let them decide what your punishment is going to be. But the first step to addressing this, Supreme Court, judges, all the rest of you public officials, is to admit that you're wrong, okay? If you continue to ignore this, there's going to come a point in time when I'm not going to be able to stop, right? What is going to happen to all of you, and you know that we are lawfully justified in our actions because the law permit whatever steps are necessary to address your criminality and your treason. We're not saying that that's what needs to happen, but what I am saying is that this is up to you.
Yep.
The destruction is on your hands, and you better figure out where you want to be. If you're too heavily and financially invested in this, then don't be surprised if placing your faith in money is going to be a very, very weak place to have that faith, right? I put my faith in God, and that's why I'm beating all of you, right? That's why we're winning, because you put your faith in money, and that's a very weak place to have your faith.
It's really, it's not just their fault. I
No.
mean, they're greedy, but we're, what do I want to say?
Culpable.
Don't pay attention.
Yeah.
We don't
Well,
know.
we're complacent because that's how we were conditioned.
taught this.
We were.
Contracts where the state is putting the DMV in their front, which is a state agency, and then you got the courts, a state agency.
Exactly.
And they're telling me that imply in consent, I signed that driver's license. That makes me in the contract. But going back to what you said on all your videos, where it says if it's void from the beginning, when it's state of Florida versus DMV falls under that too, right?
Yep, absolutely.
So
Yeah.
Yeah.
So
that contract's bad. The probation is for the state of Florida versus whoever. That's bad too, right?
100%. Yeah. So I haven't come in and talked about that yet.
Oh,
but
sorry.
no, you're
No,
good.
that's okay.
Walter, right?
Keep going.
No,
Keep
Austin
going.
Walter's
Keep
awesome.
going. Yeah.
Thank
It's
you,
all
brother.
good stuff.
So
Yeah.
so let me just say, so the indictment issue is what we're bringing to the court, right? That's a big deal. 700,000 people currently in prison here in America on direct facial constitutional violations. There is nothing keeping those brothers and sisters in that prison except for a bunch of goons with guns, right? That's it, right? That's a big deal. So right now we've got almost 500,000 criminal affidavits on behalf of these individuals that have been charged with or convicted of a crime by a justice system by way of information, not by indictment.
to
So-
be put in a corporate prison.
What? Yeah, to be put in, and so what happens then is that slavery is the basis of this issue, right? And so let's step back to the origin of our country,
I was gonna say, we're
because
all
here in
slaves to the
America,
nation, yeah.
here in America, our founders and forefathers, they started what was called an egalitarianism form of government, which is the belief that all men are equal. Well, in order for all men to be equal, government laws must treat them equal, right? That's the way our system is designed to work, okay? Well, the problem is that our founders and forefathers, they made a huge mistake, huge. And it's been leading our country to dissolution ever since it started, ever since its inception. Because our founders and forefathers, they refused to give up what they called their property, right?
Lands. Goes all back
Slaves.
to their lands. Yep.
Slaves. Slaves. They refused to give up their slaves, their
Yeah.
property, right? And that didn't make all men equal, right?
It
Because it
enslaved
built
us again.
slavery
Yeah.
into the system,
Yeah.
with a system that has the ability to perpetually discriminate. And so let's look at a couple other terms, such as the Fugitive Slave Act. A fugitive is a slave and a slave is a fugitive. Those two terms are synonymous with one another. In fact, if you were to go to Article 4, it talks about a fugitive fleeing from one jurisdiction to another. It was referring to a slave fleeing from one state to another to return that slave back to its owner. It was referring to slaves, not criminals, slaves. However, fast forward to the 13th Amendment, and let's get a little bit more terms that brought together, right? So the 13th Amendment was adopted and ratified in order to abolish slavery after 1 million of our brothers and sisters died in the war. They thought we're fighting against that. And please don't say that they were dying for anything less than that belief, because we're gonna have some fighting words there. I don't know one single brave patriot that sacrificed his life for the cause of Hurtado or the desecration of freedoms that we hold and cherish here in America every day, right? I do know that those people died, in support of the Constitution of the United States of America, because they believed in it and they believed in America. So don't say that those people died for anything less. I understand that there were probably motivations that were improper by politicians, but those brothers and sisters that died, they didn't die for anything less than fighting in the battle for equality, all right? But 13th Amendment was adopted and ratified in order to abolish slavery after the war. Now, 13th Amendment, we all believe, abolished slavery. It doesn't exist. Yay, slavery's all over here.
It's untrue.
That's not true, right? Not only does the 13th Amendment permit slavery, but it codified the legality of it within our foundational law, because it doesn't say you cannot have slavery. What it says is neither slavery nor involuntary servitude shall exist except as a punishment for crime. And the moment you say except, it means that you can have slavery.
Yep.
But we call it justice here in America now. So we took something, we retitled it something different, changed it from a private institution to a public institution, told America it doesn't exist anymore, but I'm gonna tell you right now, it absolutely does. That is what has led to mass incarceration and the 800% increase in the prison population in the last 30 years. That's why America has 16 times more prisoners than the next closest industrialized nation. That's why we have 5% of the world's human population, but 26% of the world's prison population, is because we're locking our brothers and sisters up, the weakest, most vulnerable in society, by simply labeling them a criminal in an institution where the state determines what is or is not aberrant behavior, where the state investigates whether or not you've broken that aberrant behavior or committed that aberrant behavior,
right,
where the state brings the accusation as to whether or not you are accused of it, where the state judges you for having become an aberrant individual, and then the state that profits off of your involuntary servitude and a for-profit industry for the direct benefit of the state, regional state constitutions. That's what these prisons are. They are institutions where we are sending our own brothers and sisters in to make t-shirts and sweatshirts for 30 cents an hour if they're lucky, right, for the direct benefit of the state. Here in the state of Florida, we have 140,000 prisoners here in the state of Florida. Over 40,000 of them are serving life without parole right now. These are brothers and sisters that will never, ever, ever be able to get out ever again. And they're being forced into making the chipset for General Dynamics fighter jets. Do you know how much those brothers make for that? Not 1 cent. Yeah. We have our brothers here in the state of Florida.
Free slaves, right?
We have our brothers here in the state of Florida that are answering the help desk phones for Northrop Grumman and Lockheed Martin, defense contractors. They don't get paid 1 cent to do that. We have female prisons in Georgia that are sewing the tags of Victoria's Secret underwear. They don't get paid 1 cent to do that. We have prisoners in Texas that are making McDonald's hamburgers. They get paid cents per hour to do that. We have over 900 prisoners in the state of California that are out fighting fires, making $5 per day. And then the way that we appreciate them for fighting these fires against these millionaires' homes and saving them is that we're going to send them back to their institution, pay them $5 per day. They might get 5 minutes of a hot shower. They probably won't get a decent meal, and then you're going to charge them over 1,000% increase in the price of that meal. That's not good appreciation as far as I'm concerned. And then to add insult to injury, when these people get out of prison after being trained to be able to make the chipset for General Dynamics, you think that they can have that job when they get out? No, because they have 90,000 limitations barred on their ability to go and gain employment, which means that they're going to recommit. This is a disgusting, despicable institution that the truth needs to be told about what they're really doing to the people of the United States and how they're destroying us by having a desire to proliferate and profit off of their own financial interest in these for-profit prisons. It's disgusting.
It's more than that, though, from my understanding. We're all being trafficked in one way or another, right?
Yeah. Yeah, so that's a great question, because now we can get into the familial unit, because my case is also fighting for the family. And I'd like to start by saying that every single prisoner is someone's child.
Yep.
I don't care if they're 50 years old or 2 years old, they have a mother and a father and an aunt and uncle and a grandma and grandpa that love them a lot and that would love to have a relationship with them to heal them from the trauma, whatever trauma was inflicted upon them. But the same can be said about the children, right? Because when you take a child from the love and care of his family, right?
CPS.
Right, CPS or DHS, whatever is in your state, the Child Protective
Guardian
Service.
ad litem involved.
When you remove a child from a house and from the love and care of their mother and father, then that child then grows up and becomes an adult that has an 85% likelihood of going to prison over their lifetime. So now today we have more than 12 million children that are currently removed from their family. These are 12 million children that have got an 85% likelihood of going to prison over their lifetime, and now we have a system that is self-sustaining, reoccurring, right? And it's feeding into this system, right? And we're doing it because of the trauma that we're inflicting upon these children. So We're going to be fighting for these children, all children, to get all children back home, which brings us to the real issue that we're going to argue at the Supreme Court of the United States.
Started with the children,
right?
It's going to end with the children. We're
going to start with children, and we want all children back home, their families. We want all children to get the love and care that they need, because can a state be both accuser and judge in the same cause? The answer is absolutely not. Absolutely not. If a state agent, any state agent, brings an accusation against you, then the same body of men that represent the state cannot be presumed to be neutral and unbiased to act as the judge against you. Therefore, the judge has a automatic recusal requirement to recuse himself because he has a conflict of interest. He works for the plaintiff. Let me break that down for a moment here, because that's the issue we're going to litigate, right?
Yep.
Can a state be both accuser and judge? Cannot. Because the Constitution of the United States, Article 3, Section 2, it identifies two different jurisdictions of the United States Supreme Court. One is original jurisdiction, the other is appellate jurisdiction. Now, original jurisdiction means that that's the court to act first. No other court in the country can act before the court that has original jurisdiction. So, we all believe that that court is a court of appellate jurisdiction, that we go to them last, not first, we go to them last. And that is true in all cases except for if a state is named a party. Because Article 3, Section 2 says, in all cases in which a state shall be party, the Supreme Court shall have original jurisdiction. It goes on to say, in all other matters of equity and law, the court has appellate jurisdiction. Problem is, original jurisdiction hasn't been invoked in this court since 1890.
I was going to say 1892.
Because we've forgotten original jurisdiction. Now, you know what? Maybe I'm interpreting that wrong. Maybe when it says that in all cases in which a state shall be party, the Supreme Court shall have original jurisdiction, maybe that means that they don't really have it. So let's see if we can find some additional witnesses to add credibility to that. So the Federalist Papers is what we would typically go to if we want to interpret the original intent of the Constitution. In fact, Justice Gorsuch, United States Supreme Court, he's going around the country right now talking about how James Madison is the authority on the Constitution. We go to him to understand anything because he's the father of the Constitution. Well, let's see what James Madison had to say about that. James Madison wrote the Federalist Number 10. This is the earliest known reference to the modern day concept of conflict of interest, the earliest known reference. This was written on November 23rd, 1787. The article was titled "The Union as a Safeguard Against Domestic Faction and Insurrection," and in the article, James Madison said, "No man is allowed to be judge in his own cause because his interest would no doubt bias his judgment and not improbably corrupt his integrity. With equal, nay, with greater reason, a body of men are unfit to be both judge and party at the same time." A body of men are unfit to be both judge and party at the same time. James Madison, you told us exactly why you wrote Article 3 the way you did. A body of men are unfit to be both judge and party at the same time. Therefore, if a body of men bring an accusation against you, the same body of men cannot be judged against you. Therefore, the federal judicial authority of the Union must extend. But you know what, James? Maybe I'm missing that too. Maybe James Madison said it wrong. Maybe I'm interpreting. Let's see if we can find another witness. How about Alexander Hamilton? He also wrote the Federalist Papers, right? We can go to Alexander Hamilton. He wrote the Federalist Number 10, Federalist Number 80. And in the Federalist Number 80, he provided two references to this issue. The first is, the federal judicial authority of the Union must extend to all cases between a state and the citizens thereof. If there's a dispute between a state and the citizens within that state, the federal judicial authority must extend. Thus, the federal Supreme Court must extend. Alexander Hamilton. Now, the second reference that he made is he said state tribunals cannot be presumed to be impartial when they speak for themselves. No man ought certainly be a judge in any case in which they have the least bit bias or interest. So again, state tribunals cannot be presumed to be impartial when they speak for themselves. That's pretty clear too, right? Okay. So there's two of the Federalist Papers, two of the authors of the Federalist that made reference directly to this issue that say, who was the third again? How about John Jay, the first Supreme Court Justice of the United States of America, right? United States Supreme Court. Chief Justice Jay didn't state within the Federalist Papers this issue, but he sure the hell did in the case called Martin v. Hunter's Lessee, United States Supreme Court, when he said that the Constitution has presumed that state interests, state biases, state prejudices might from time to time obstruct the administration of justice by state judges. Therefore, it is the case and not the court that grants original jurisdiction to the Supreme Court. It is the case and not the court, because the Constitution says, in all cases in which a state shall be party, the Supreme Court shall have original jurisdiction. So now we have all three authors of the Federalist Papers attesting to the fact that a state cannot be both party and judge in the same cause. And now let's go ahead and see if we can find some law to back that up as well. How about the federal the Judicial Code, Title 28, subsection 455, the Judicial Recusal Code. Title 28, subsection 455, very, very powerful if you guys want to hold judges accountable. What it says is it says that a judicial officer has an automatic, mandatory, non-waivable, self-executing duty to recuse himself if, scroll down to item 4, he is an officer of either party. These are judicial officers of the state. State is a party. Therefore, they have an automatic, mandatory, non-waivable, self-executing duty to recuse themselves. Failure to do so means that they're acting without jurisdiction.
Treason.
And according to United States versus Hill case, United States Supreme Court, anytime the judge acts when they have an automatic recusal, they are now warned against Constitution committing the crime of treason, right? Already litigated. So once again, judges, you might want to figure out where your faith is at real quick, because if you are taking action in a case in which you have a conflict of interest, you are committing the crime of treason, right? And so that brings us back to the J6 issue, because, you know, over here at the states, I'm battling with the states because the states say, oh, Title 28 doesn't apply to us, right? Well, great. We'll litigate that in court. But I'm going to tell you right now that every single United States judge of the United States of America, Title 28 does apply to you.
It does.
So why is it that a judicial officer of the United States of America is standing in judgment on a case in which they're an officer of the party? It's United States of America versus J6ers, right?
Right.
So how can a federal judge sit in that, right, when he is an officer of the party? The reason why is because the way that our system was designed to work, our Constitution created limited government. We have to have limited government, which means that if a state brings an accusation, the federal judicial authority is the judge. If the federal government brings an accusation, the state is the judge. Article 3, Section 2, in all cases in which a state shall, the trial of all crimes, with the exception of impeachment, shall be by jury, and the trial shall occur in the state where in which the crime is said to have been committed, is because if the laws of the United States are brought against, an accusation is brought against the people, the state is the judge, thus limiting power. If the state brings an accusation, United States of America is the judge, thus a limiting power, because it's a different branch of government that is now judging from the one that's seeking the enslavement.
I'm trying to figure out how to explain this and boil that down. And I was a judge, I could go rob a bank, bring up a case against me, and basically I could say, no, I didn't rob the bank. You say, yeah, you did. And I said, no, I didn't. I'm the judge, basically. Is that sort of kind of what you're explaining?
Well, so the judges believe that they're immune, right? They claim immunity. But what we need to remember is that there's two different types of immunity. There's civil immunity and there's criminal immunity, right?
And that's where your oath comes into play.
So the judges today, if the state creates a law, because states were not supposed to have laws, this is the whole Chevron issue. The states were not meant to have their own laws, right? Because here in America, we have a representative government, right? We have a republic, right? And it's a federal republic. And what a federal republic does is the central government creates laws and then federate them out to each of the regional governments for application administration. So we come together with a representative government, equal representation of each of the regional governments. They create the laws. Then they federate those laws out to all the regional governments for application administration. Now the judge can be neutral and unbiased because he doesn't represent the government that creates the laws.
Right.
But what that also does is that ensures that all persons across the United States of America are all treated equally because the laws apply equally to every single person.
Right.
That's the way that's supposed to be. We were supposed to have the central government create the laws based upon every single state having equal representation and then federate them out. Because remember, a confederacy is a sovereign state not subject to a higher government's laws. If the state is able to create their own laws, then that means that they're sovereign to the United States of America. That was not what we created. Yeah. So, the real issue is what are the states' roles within our system of government? Are the states sovereign? If they are, Constitution, it's purposeless.
Well, that goes back to their state constitutions, right? So basically, are they ratified by we the people? We're finding out more and more that they're not, right? Or they've been hijacked as well. And then obviously that goes down to the county level, and then from the county level, we're finding out that there's charters, right?
Yeah.
So over the cities.
Right.
So they've built this montage of layers
Yeah.
to literally hijack what we should be going back to.
And so that therein lies the issue of Chevron.
Right.
Because what was going on with Chevron 40 years ago, and I want to call attention to the fact that mass incarceration started 40 years ago.
Right.
800% increase the prison population in those 40 years. 800% increase. What led to mass incarceration but for the executive branch saying it's not clear whether or not we have to have an indictment, therefore we're going to charge by our own discretion? The purpose of the grand jury. The purpose of the grand jury is to protect the accused from hasty or malicious charges by an overzealous prosecutor. The purpose of the grand jury is to protect you from the prosecutor, and yet in 99% of the cases where a grand jury is performed, the accused is not given the right to be present to benefit from the very proceeding that exists for their protection. And the reason why they're not being there is because the prosecutor is preventing them from being there. So the very proceeding that exists to protect you from the prosecutor is being denied from you by the very person that you are to be protected from for that proceeding. That's a crime. It's called obstruction of justice. And when two or more people do it, it's conspiracy to obstruct justice. So conspiracy to obstruct justice derives from Title 42, subsection 1981. This is civil law, but from civil law derives the enforcement law. Just remember that. But what 1981 says, it says all persons within the jurisdiction of the United States shall have fair and equal benefits of all laws and all proceedings. So the Fifth Amendment is a law created by the United States of America. Therefore, it's protected by 1981. The grand jury is a proceeding created by the Fifth Amendment. Therefore, it is protected by 1981. Therefore, when the prosecutor conspires by and between the accuser to deny the accused the right to be present to benefit from the very proceeding that exists for their protection from the prosecutor, the crime of conspiracy to obstruct justice has occurred. And what that enforcement statute says, when two or more persons conspire for the purpose of preventing any party in any cause from participating in said cause, commits that crime, right? And by that criminal act alone, that indictment is created as a result of that crime. Therefore, the indictment doesn't exist. You're still charged by information. So if you weren't present in that grand jury to confront the hearsay accusations against you, you were charged by information.
Yep.
There was a crime that was committed in order to create that alleged indictment, which means it's not an indictment. It's an information erroneously titled indictment signed by the prosecutor. That's what that is. So Chevron, right, 40 years ago, the United States Supreme Court came out and said, executive branch, if you're not clear on the law, you can write policy that will alter the law and provide clarification. It was the law of deference. So what they were doing was, if they found ambiguity in the law or they were unclear on the law, they would write policy executive orders, because the executive branch creates orders. They would create executive orders and then call it policy, and then they would go out and enforce that policy as though it's law against the people. Well, last year on June 28th, we got the Supreme Court to provide a ruling. I wasn't the one that brought it, but I was absolutely the one that brought the pressure to require the court to make the decision. Because Chevron was on June 28th, and remember, the court stayed 3 extra weeks into their recess just to make this ruling, right? They stayed extra 3 weeks into their summer recess in order to make this ruling, because on May 20th of last year until June 6th, I went around and I served 44 state attorney generals with notices that their prosecuting attorneys are committing crimes every time that they rely upon a policy to charge a person by information, not by indictment. I went around and I served those 44 state attorney generals with notices, actual affidavits of victims within their state, letting them know that their prosecuting attorneys, their agents, are committing these crimes and asking them to correct the unlawful acts of their agents. We received 2 responses back from those 44 state attorney generals. One came from Bob Ferguson, the Attorney General of Washington. What the Attorney General of Washington said, Mr. Ferguson, he said that the Fifth Amendment doesn't apply to the state of Washington. Let me say that again. A sitting chief executive officer of a state said the Fifth Amendment doesn't apply to the state of Washington. Well, that's news to me. That's going to be news to 330 million people, but that's also treason, sir. And unfortunately, the Constitution says that treason must be committed in open court, and you, sir, responded to that in open court. That was your official response to the civil action that we brought forward. I think you're in a little bit of trouble, sir. You might want to go ahead and mitigate your culpability soon. Now, the second response we got back was from the Attorney General of the state of Rhode Island. Now, the state of Rhode Island, what he said is, we're aware that these statutes are unconstitutional, but we're going to continue to enforce them until directed otherwise. That's not going to go real good for you, sir. Not going to go real good. You want me to know why? Is because when you say that we're aware that what we're doing is unconstitutional, when you say I'm aware that what we're doing is unlawful, that's mens rea.
Right.
You just established a guilty mind. You said to us that you're aware that what you're doing is a crime, but you're going to continue to commit that crime until your boss tells you not to. And there is no ignorance of the law. You have no authority to break the law, Mr. Attorney General of the state of Rhode Island.
So
therefore, you have now established mens rea. We have the actus reus. We have the corpus delicti. And you, sir, have got a very, very short rope on you as well that you might want to get corrected here.
So do you think that in some cases, like your two responses, right? They've admitted to guilt. We know that Trump is pretty much letting them expose themselves. So how does this all play into awakening the public to start bringing awareness? Obviously, get out there, be activated, fight back, or at least bring it to the local attention, to bring it to the state, and then therefore and to support you as well.
Yeah.
Because that's the thing that we're missing right now,
Yeah.
right? We're aware of all these little situations,
Yeah.
and we're doing much, you
Yeah.
know, social media warfare as you can, right? Because
Right.
we're in a social media war, and
We
everybody
are.
knows
We are.
that. We're at World War III.
Yeah. I mean, I've got a great message, but yet my message isn't getting put out there.
Right,
You
and
know?
we're all being suppressed, and especially you. I posted.
Let me finish this and then
Yep. I posted, you know, all kinds of information with you, and they shut my Facebook off. And,
Yeah.
and we've been doing this for 5-6 years.
Yeah.
So how do we informational warfare? How do we get the public activated? How do they get in contact with you?
Yeah.
How can you be supported? Because definitely we want to get the awareness out there.
Yeah.
And continue on your battle. And obviously we need to get
Yeah.
more people to stand up.
So let me explain what I'm doing, right? So 9 years ago, when I realized, because I took an oath as well, I swore that I would support and defend the Constitution of the United States against all enemies, foreign and domestic. I have an honorable RER 1 discharge. I can be recalled into active service at any point in time. Because of that oath, right, which is the only thing that gives any public official their authority to do anything, is that oath. I myself have an oath. And because I can be recalled into active service at any point in time, that oath is perpetual, binding, and self-executing. So when I encountered someone domestically, judges that were warring against the Constitution, I had an obligation to step up and do something about this. It wasn't a choice for me because I had made a promise to people in the United States that I would do exactly what I'm doing, and I have an obligation to do so because of that promise. So 9 years ago when I stepped up, right, I had to make a decision. Am I going to continue to act unlawfully once I was made aware that I was acting unlawfully, or am I going to do something about it? So when it comes to the crime of criminal conspiracy with regard to public officials, what it says is any person who, having knowledge of any of the wrongs conspired to be done, and who have the power to prevent or aid in the prevention of the commission of the same, neglects or refuses to do so, may be joined to dispense the action. So that means that if you're made aware of a criminal conspiracy that exists to undermine the laws of the United States, you have an obligation to stand up and do something about that. And if you don't, willfully or negligently, it doesn't matter.
Right.
You are now a part of that criminal conspiracy. If I'm aware that someone is going to shoot someone else and I do nothing about that, I may as well be the very person pulling the trigger because I knew about it and continued to allow it to happen. Public officials, that's the crime that you guys are facing here, right? But when it comes to a criminal conspiracy, to mitigate your culpability once you're a part of it, you can only do it one of two ways. One, you must notify the authorities of the crimes, right? Which if you are the authorities, that doesn't do any good. Or two, you must notify your co-conspirators of your intent to no longer participate, but that must be done by affirmative action. So let me break that down. So I want you to understand state Supreme Courts and state Attorney Generals, all of whom I've served. I've served 44 state Supreme Courts, 44 state Attorney Generals with these notices that their agents, the judges and prosecutors are committing these crimes, asking them to step up and correct their unlawful acts. When you guys failed to take action, willfully or negligently, you yourself are a part of it, and now I don't have to serve any of your prosecutors with a notice or any of your judges with a notice because I went to their boss with a notice. And their boss failed to take action, which implicates every one of those agents in it. You guys are all done. Judges, prosecutors, law enforcement, you're all done. You've all been served because I went to your boss, the highest boss in your state, and notified him. And when he failed to take action, he implicated all of you in this. But each and every single one of you have the ability to be able to mitigate your culpability but it must be done one of two ways. You must notify the authorities of the crimes being committed, or two, you must notify your co-conspirators of your intent to no longer participate. But that must be done by affirmative action. We must see what you do. You must do something. And if you do not, then just understand that by doing nothing, you're still doing something, and that's the wrong thing to do because you're still a member of that criminal conspiracy. But I want to bring attention to one item right here. Law enforcement, judges, prosecutor. When it comes to notifying the authorities of the crimes, I want to remind you that the only agency that has the authority to investigate the deprivation of rights under color of law is the FBI. So it's not up to you, Attorney General, to decide whether or not you are going to investigate this. It's not up to you, state police officers, to determine whether or not you're going to investigate it, because you have no authority to investigate it. Yep. You must forward this on to the FBI and direct them to investigate this. And if you do not, then just understand you have not notified the authorities of their crimes, and you are implicated in it until such time as you direct the FBI to investigate and address this issue of your agents that are acting criminally to undermine the laws of the United States. So there's the situation that we're in right there. It's a pretty big situation because not one Attorney General has forwarded this on to the FBI. Not one state Supreme Court justice has forwarded this on to the FBI, despite being made aware and having almost 1 year time to think about it. That's not mitigating your culpability. That's enjoining you in this litigation, which is why right now we have 44 states enjoined in the case that I have. If I beat the state of Washington, which I can, I said that in the very beginning. If I beat the state of Washington, I show that Washington State's Constitution says we're not going to do a grand jury. Constitution of the United States of America says you have to do it. Then guess what? I'm going to beat you, Washington. And when I do, because I already have these other 44 states enjoined from the Attorney Generals and the Supreme Court Justice failing to take action, then we will provide relief to all 44 of these states. This is going to be an instant, massive reconciliation of a massive amount of fraudulent debt created by states that have no authority to be able to create that debt, because what they've been doing is based upon policy and not law.
And the longer they wait to do that, the more the crimes are piling up.
Right.
Yeah.
Well, yeah.
Now, so when I was in Minneapolis, right, the sheriff of Hennepin County, he came out and he wanted to meet with me before I had our event there. And he took his patch off of his uniform, gave it to me and said, "I support you. I believe in you." He said, "There's more people than you can imagine that are behind you on this." Privately, not publicly,
Right.
Privately.
Yep.
Now consider that I've got 500,000 criminal affidavits, roughly 500,000 sitting in the back of our car right now over across the street. I'm driving around the country with this information that's going to bring this system down. With the side of my van plastered in white, "We shall be free," and I'm allowed to continue to do this, right?
Doesn't matter if we're allowed.
It doesn't matter because they are scared of what we're doing.
Yeah.
And the truth is they know we're right.
Yep.
I have governors that I've had dinner with. I've had representatives I've had dinner with, and every single one of them say, "You're right, and we support you privately, but not publicly."
Right.
What that tells me is that I'm going to have to get there on my own. No one's going to help me get there.
Right.
But once I get there, I'm going to win without even a fight because they all believe in it anyway. They're permitting me to do this. They're permitting me to continue knowing what I'm doing. I'm 16 days out from delivering all the evidence that's necessary to take this court down from 243 years of unconstitutional actions and contracts being created in violation of the supreme law of the land, the one thing that their institution was created to preserve, protect, and defend. I'm being permitted to do this. So I just want everybody to understand that we have a massive amount of power when we speak up against the government. I don't fight for anything but the Constitution of the United States of America. That's the only thing. That's what I believe in. Because if we can't believe in it, right? If we can't believe in its supremacy and the words that it says and believe in the power that it has, then I'm afraid we've lost this country.
Yeah.
And I don't want to live in a world that doesn't include America. I love this country, right? So I kind of want to end with this, or I know there's a couple others, but a patriot is defined as one who loves and defends his country, right? And I'm proud to say that I'm as much a patriot as this country's ever produced. I'm honored to have followed these millions of people that have died before me to show me how I need to act, right? Because it's an honor to. But if you love something, destruction would never be an optional outcome for that that's loved. A patriot is not going to call someone to arms. It's not a call to go get your guns and go start shooting each other, right? Patriotism is a dialogue. with your fellow man about what is good about your country, but how your country can be better, because patriotism is rooted in humanity, right? And it brings peace and harmony,
Exactly.
right? Nationalism is a pride and arrogance on how great your country is without any self-introspection. And that's what we become. We become a nation that is now talking about how amazing we are without looking at our own issues. Any domestic policy that is in conflict with foreign policy is rendered ineffective, and we are rightfully labeled hypocrites. So before we can go into another country and demand that they set their people free, we need to first take a look at ourselves and say, do we practice here at home what we're preaching overseas? And the answer is we do not, right? Because we have 16 times more prisoners than the next closest industrialized nation. We have 5% of the world's human population, but 26% of the world's prison population. Why is America so bad? Because we have criminals that are leading us. So the way we're trying to solve this issue of criminality, by going out and arresting the people for the crimes they commit, it's never going to work. That's what's led to an 800% increase in prison population. Because if our country is being led by criminals, and remember, a criminal is defined as one who transgressed the law. If you transgress the law, you are a criminal. So if our country is being led by criminals because they're not following the fundamental laws that bind and adhere them to their office, then that means that they're acting unlawfully, and that makes them a criminal. So the issue of criminality, it must start at the top. We got to go to the top. We got to hold the leadership accountable. We got to make sure that we have officers and leaders that are going to lead our country in a lawful direction. Out of love, faith, obedience, and respect for the law and the will of the people. And until we do that, everything that they produce is unlawful because of their own unlawfulness. Because government cannot break the law in order to enforce the law. There is a maximum law that says that any act unlawful at the beginning cannot become lawful over time and by subsequent legislation. As long as you are acting unlawfully, government, nothing that you produce is going to be lawful. Therefore, I would seriously recommend and implore you to step up, take a look at what you're doing, right? Self-reflect, a little introspection, and decide, is this how you want to be remembered?
Amen.
Because you're on the verge of being remembered as just that, traitors and criminals. Thank you so much. God bless.
Tanawah, thank you. And how can people get a hold of you to donate, help your cause, get you to
just find out
DC?
more.
And obviously, your affidavit's online where they can contribute as well, and bring awareness. So please explain that.
So we have a 2-page affidavits, right? Both for the family unit, if you've had a child taken without lawful authority by a state, or if you've been charged with or convicted of a crime by the state, we have 2 different affidavits. They're very, very simple, right? And what they're doing is they're placing everybody in the same procedural situation. This is very important, right? Because in order to have a class action, you have to have everybody in the same procedure,
category,
right? So I don't want to know who the officer's name is. I don't want to know who the judge's name is. I don't want to know I don't want to know if there were 5 officers, because what I do know is that someone arrested you and brought you in front of a judge because of someone's improper charging instrument, and those 3 people entered into a conspiracy to deprive of rights the moment they did that, right? So it's 2 pages. We're not adding anything else into it. It's very, very simple. Do not add anything in besides those, but we need as many of these as possible, because this is what you guys are going to empower me to push me into the court. And then what we're doing is I'm able to litigate one issue on behalf of the whole party. I know that there were other officers involved. I know that maybe a different agency was involved, but what I do know is that a police officer arrested you, a prosecutor charged you, and a judge held you over, and those 3 facts establishes the material facts. Everything else is secondary. Did the state follow the proper rules and act lawfully or not? The answer is they acted unlawfully. So we need as many affidavits as possible. So you can download the affidavit from www.tanawah.com. That's TANAWAH.com, right? The affidavit is top right corner. Download the affidavit. If you want, you can also send an email to us. The email is TANAWAHDOWNING. That's Tanawah Downing @gmail.com. You can send an email. We'll get you the affidavit. It's readily available on our TikTok, right? That's Tanawah Downing @Tanawah Downing, or on our YouTube. That's also @Tanawah Downing. We have Instagram @Tanawah Downing, and we also have Facebook Tanawah.Downing.5. You can find all this information. We've got thousands of videos on TikTok. You guys are welcome to go out there. So you download the affidavit, and then we have a mailbox in North Carolina, right, that's available. You can get that information also from TikTok or wherever else. We'll be
posting all of the links and everything.
So you mail that in, and as long as we get it there before June 7th, we'll be able to include you in. That means that if I effectively litigate this, if I argue on this issue that can a state be both accuser and judge, can a state create its own law that interferes with the fundamental rights of the Constitution, if I can effectively litigate that for one person, I can effectively litigate it for 2.9 million people currently in prison here in America or that have been imprisoned in the past. So this is an opportunity for one case to overcome millions of cases, because that's why the TERS motto is one question, one action, every prisoner. We got one question for that court. Have you acted lawfully over your 243 years? And the answer is no. The answer is no. And that affects every single prisoner, be it a prisoner as a child through CPS, be it a prisoner through a guardianship as an adult, or an elderly guardianship as well. Those are the three elements that we're going to be able to effectively overcome, give the people of the United States their freedom back that were taken without lawful authority by this agency. So you can get in touch with me through those social media points. And then the last thing is 9 years ago I chose to do this because it's the right thing to do. You know, I realized that I was not being a good example for my son. It's not being a good example for my daughter. So 9 years ago I chose to step up and to do what I needed to do to make sure that I set the example for them. If I'm going to be proud of the man that my son becomes, I must first be proud of the man that he emulates. So I'm out here setting an example for my son, showing him, son, this is how a man acts. This is what a man does. We're going to stand up. Even if it doesn't make sense, even if it hurts you and your sisters, we're doing this because it's the right thing to do, right? But I don't get paid to do this. I operate on donation only, because these people that are in prison, people that are having their children taken, it's happening because they're poor. So I operate on donation only. Last night we slept in a van. Sometimes we got to do that, but at the end of the day, it's a real honor to serve people in the United States, and I will continue to do this. If I have to walk to Washington, D.C. with these affidavits, we will do that. But we'll do that because we love all of you, we love our country, and I hope that you guys will get behind this, support it. If you guys want to, we have Cash App, Chime, Venmo, PayPal. They're all exactly the same. It's We Shall Be Free. That's WESHALLBEFREE. We shall be free, and we only got a couple weeks left. We hope that you guys will help support and make sure that we make it to Washington, D.C. On time. Thank you guys so much.
Yeah, definitely donate if you can. Download the affidavit, and bless you, to see where he's going to be next.
And you folks that are been wondering what you can do,
this is an actionable opportunity to stand up and stand up for your rights.
We also have a rally that we're planning right now on June 7th. So the last event that we're doing is going to be in New York City. New York City is extremely important. I want to take one moment
Might have to be taking the road trip.
So we're going to be doing it at Ground Zero, because there's so much about that story that has not been told. In fact, we're starting at 10 a.m. because the towers fell at 10:28. We've got some reverends that are coming in. We're going to be saying a prayer at 10:28, the moment that the towers fell, and or the second tower fell. But we're going to start at 10 a.m. at Ground Zero on June 6th. Now, I do want everybody to know that I did serve the state of New York on behalf of Donald J. Trump.
Nice.
He was the affiant for the state because Mr. Trump was denied his right to be president, to confront the accusations against him by the Attorney General, Letitia James. We served the state Supreme Court and the state Attorney General on behalf of Mr. Trump. I'm praying, Mr. Trump, that you'll get behind this finally, because it's been a year now that you've known about this, and we would really, really like you to get behind this, because my argument will also help you, sir. Because what they did to you was unconstitutional, illegal. It was a crime, and by that crime, there was no indictment that existed. Therefore, your conviction by a trial derives from that unlawful act. So, sir, if you get behind this and you help us when we get there to New York City, this will benefit you. And so I pray, sir, that you'll get behind this, because this is very, very important to address the criminality of our leadership by holding them accountable to the limits that are in place by our Constitution of the United States. So I pray that you get behind this. But New York City is very, very important because, again, remember my background, right? 9/11, Homeland Security. That was the moment that Homeland Security came in, this terrorism entered into our own country. And I think it's important that we close this out, this whole event out right there at Ground Zero, talking about what happened to our country on September 11th, 2001. And then we leave New York City, head back into Washington, D.C. We're going to have a rally on June 7th and June 8th, and then we're delivering all this back to the United States Supreme Court. They're expecting it. We got 6 justices that are in support of this already, so I think we're going to have a unanimous decision personally. But so Supreme Court, I also want to say that if you want to stop this train wreck from coming, if you want to avoid having this discussion in a public domain, You can sign that writ that was delivered to you on September 29th, 2023 under the case Tanawah M. Downing versus State of Washington, and you can end this before we get there. You can do the honorable thing. You can obey the law, and by your edict, you will direct all the judges within the country to obey the Constitution of the United States. But you guys are going to have to make a decision to do that. You can either have this in a public domain against me, or you can do it privately, in which case we can save the country, and you guys can do the honorable thing. And Mr. Thomas, you can retire into obscurity, never be heard from again. You can be the hero, but you're going to have to take action and lead your branch into a lawful direction. Amen. So I would challenge you to do that. Step up, discharge the duties of your office, fulfill the obligations and promises that you made to the people of the United States, and sign that writ, Mr. Thomas. Sign it, because I know you're thinking about it. I know it's sitting on your desk. Sign that writ, retire, and be the hero that you've always wanted to be. And let's fix this country from your own institutions, illegal and unconstitutional acts. Thank you, guys.
Amen.